Number 3, matter of James Q. versus Commissioner of the Office for People with Developmental Disabilities. Counsel?
May it please the court, I'm Brent Stack, Mental Hygiene Legal Service, on behalf of appellant James Q. James Q is asking...
Counsel, would you like to reserve any rebuttal time, sir?
I would, thank you, Your Honor. 2 minutes, please. James Q is asking this court to reverse the opinion and order of the Third Department and direct that the record of his CPL 33020 proceeding be sealed in its entirety.
Also, just to clarify, under the Third Department's ruling, since it provides for redaction, what's the information that you say would not be redacted that would have been covered by the sealing? Since everything's going to be sealed, I want to know, what is it that's left that you're particularly troubled by?
Well, I think that raises one of the primary issues with the Third Department's decision. What would be redacted would be determined on a case-by-case basis by a Supreme Court judge. There would be essentially redaction litigation. MHLS would argue that the patient should have the full force and effect of mental hygiene law, section 3313C, which makes confidential any information that identifies.
So are you looking for an all or nothing result here, sort of? Are you gambling on an all or nothing? Not, I shouldn't say gambling, but are you advocating that it should be all sealed, but if it's not going to be all sealed, then there shouldn't be any redaction, it should just be as...
I mean, confidentiality should be the rule. There are certain exceptions to the rule, provided both in MHL, or Mental Hygiene Law, Section 3313, as well as CPL.
Well, let's talk about confidentiality. In these cases, we have public hearings, don't we? And at those public hearings, the defendant is obligated, has a burden of proof. It's either a plea or it's a trial, has a burden of proving the defense, right, with particularity and medical testimony and all sorts of, and other evidence. That's all public. So what is, I don't understand why then, when that is the case and this defendant has put his or her mental condition into dispute, why is it then that the court is required to seal its records?
James
and
Q
where
is not
does the statute say that it does?
James Q is not asking for the initial criminal proceeding to be sealed. He's only...
A retention hearing is also...
A retention hearing is a civil proceeding that's post-verdict or post-plea. Post-plea, CPL 33020 provides...
Yeah, but just to follow up, though, on what Judge Stein was saying is, her point, the way I understand it, is at trial, you go forward, you have to prove your defense, and in the context of improving, you're not guilty by reason of mental disease or defect, you put all of this medical proof in the record to establish that. That's the way it's done. And so a retention hearing simply does a similar thing. It reviews the current state of that person, the current mental state of that person, and then it makes a determination of whether or not they can be released, whether or not their proof is sufficient to show that they can be released. What's the difference?
Well, the difference is that CPL 33020 proceedings, at that point, the individual becomes a patient. And
so the difference then is between the civil and the criminal nature of the proceeding, right? That's the first thing.
Correct.
And the second, which once there's a determination that a person is not guilty by reason of mental disease or defect, then we're saying, the state is saying that this person has a disease and that therefore their disease gives them certain rights. Would we agree on that? Certain rights to their protection, confidentiality, and to certain records, right? Sure, of course. So that being the case, then, this is why the appellate division I kind of understood what they were doing because they seemed to be drawing a distinction between, at that point in the proceeding, between the court records and the clinical records. Clinical records not being accessible, court records being accessible. And that seems to be a rational distinction to draw in a civil proceeding that you perhaps wouldn't draw in the initial determination in the criminal proceeding.
I think that's an impractical distinction.
Okay, tell me why.
Because the court records contain information that is made confidential by statute, and that statute is Mental Hygiene Law, Section 3313C. And that statute covers any information that would tend to identify the patient as a patient, identify any diagnosis, and identify any care and treatment. So the petition itself would identify the patient as someone who is mentally ill or alleged to be mentally ill. It would contain information specific to that mental illness. It would identify.
Is there any reference along those lines in 3313C permitting disclosure to the courts for information required for the retention hearing?
3313C?
Yeah.
Information to the courts?
Well, that's where they set forth the exceptions to, it permits disclosure of certain things. They
court-
don't refer to the courts. It doesn't refer to the courts at all, does it?
At a retention proceeding, the court would have access to all of the information.
Well, but it doesn't say that in 3313, right?
3313 is a confidentiality provision regarding a patient's right to confidentiality.
So I guess
A
that's my
court would-
point. My point is that is meant for the facility, that it is not meant for an independent body, the court, that is adjudicating these situations.
Well, the regulations, specifically 22 NYC RR 38.1 sub 4, requires the courts to adopt rules providing for the retention and disposition of court records. Sub 4, including provisions to ensure the confidentiality of court records sealed or otherwise made confidential by law. So the courts do have a duty to protect the confidentiality of not only records that are sealed by court order, but those records that are made confidential by
Counsel,
law.
let me ask you about a provision in 330.20, because I thought it supported your argument, but I'm just not sure. So 330.27 says the latter order, and it's referring there to the order where the court determines that the individual should be committed to the custody of the commissioner. So this is after the conviction, the plea, this is after the examination, this is after the hearing, the initial hearing, and this is the decision of committing someone. It says that order shall be deemed an order made pursuant to the mental hygiene law and not pursuant to this section, which is referring to CPL 330.20. And further, retention, conditional release, or discharge of such defendant shall be in accordance with the provisions of the mental hygiene law. Was your argument that then, as a result, the individuals who fit under 330.20, once there's an order of them being committed, now are essentially individuals who fit under Article 9, and so the sealing provisions also apply in that sense?
In that sense, yes, Your Honor. That section is specific to Track 2 and Track 3, CPL 330.20 patients, and it specifically states that further proceedings shall be governed by Article 9 or Article 15, and that would certainly include those sealing provisions.
What about track 1?
Track 1 is governed by the balance of CPL 330.20.
So, counsel, the retention hearing is conducted under CPL 330.20. What's the impact and interplay of CPL 160.50, the sealing provision, which lays out the occasions on which records and proceedings are sealed?
I'm not certain of the interplay between those two provisions. I believe that the balance of CPL 330.20 does talk about notice to certain individuals, including the district attorney, and any other individual that the court may deem necessary to receive information and an opportunity to be heard. And that's where the public protection comes in. And specifically, for Track 1 defendants, they cannot be moved to any lesser restrictive form of hospitalization or care and treatment unless the people are given notice to be heard, and that's through the district attorney's office, including any other person, which may include the victim or any other person deemed to be notified as a necessity by the court. So that's where CPL 33020 does pull back some of the confidentiality protections provided by the mental hygiene law, and they're specific to 33020, and that's in line with our argument in which 330.17 states that the mental hygiene law shall apply to these individuals unless specifically limited or otherwise excluded, specifically by this section, by no other operation of law, but just by 33020.
If I may, I know there's about let's say we don't agree with you about the wholesale sealing. What should we do with the redaction language in the appellate division decision, and particularly to the extent that they seem to indicate that it's as a matter of law? Should this be a discretionary thing on a case-by-case, or always redacted, or
I think
what should we do with that?
I think that highlights the problematic nature of the decision rendered by the third department, because it's going to lead to different results in different courts and for different patients. Some patients are going to be entitled to more confidentiality, and some are going to be entitled to less, and you're going to have an entire class of persons statewide who are treated differently by the law. And aside from that, you're going to have a logistical problem in the clerk's offices, because there are still people that are entitled to access to these records under different provisions of the mental hygiene law. And if you've gone and now redacted all of the records, those people who seek access are going to get access to records that don't provide, in many cases, don't provide any useful information at all.
Can we reach the redaction issue? People didn't appeal that, right? It's not a ruling adverse to you.
I suppose it's not adverse. Well, it is adverse to us, to our clients. In this case, James Q's record has been sealed in its entirety, awaiting this court's determination.
Well, just to follow up, the provision that of the appellate division saying that it's not sealed entirely is adverse to you, but the provision that says, but we're redacting this information, how is that adverse to you?
Well, we've already seen this become an issue at the Supreme Court level because courts do not know how to apply the third department's determination, because it's still, like I said, it leads to
Well, then the
further
adverse
litigation.
decision would be the refusal to redact something, not the redaction.
It could lead to, on a case-by-case basis, redaction litigation, which is then appealed.
I thought it was adverse because part of what you say needs to not be public is the identity of the individual.
Correct,
And
Your
that will
Honor.
stay because you've got the order and you've got the petition, correct?
Unless those documents are so redacted that you can't tell.
But the majority didn't order that redacted.
No, they did not. So you
Thank you,
still have
counsel.
information. Thank you.
Thank you. Counsel?
May it please the court, my name is Guy Arcidiacono. I'm an assistant district in Suffolk County. Defendant pled not responsible by reason of mental disease or defect to a number of charges, and by raising and accepting that affirmative defense, he placed his mental condition in issue. That is a fundamental difference from strictly civil cases, and it is a fundamental difference here.
Well, sure, at that hearing, but then once you have the determination, the statute seems to say that these individuals are then protected by the provisions of the mental hygiene law, and that's what your adversary is arguing about, not the initial proceeding, and so that's really not the focus of the statutory construction argument here.
The inquiry doesn't end there, Judge, because subsequent proceedings, at least in most courts throughout the state, are still public.
Well, but that's the question that's driven in this appeal, right? Whether or not there are provisions of the mental hygiene law that require the sealing here? That's the merits argument. So why don't you get to the merits about whether or not the law doesn't require that?
Okay, well, first of all, 3313 is obviously part of the mental hygiene law, but it is subject to the limitations specifically stated in 330.20.17.
And does 330.20 anywhere say that you cannot seal?
No, and neither does it say that anything should be sealed.
But
And as
what
the
provisions of the mental hygiene law do? Wouldn't that be a way to
Well,
harmonize it?
3313 is a confidentiality provision, as the third department pointed
But
out, and they also,
it does say they're not public records, right? So it then
As
goes
far
on
as it
to
goes.
explain to the facility what to do with the fact that it is the repository of records that are not public.
well, if you look at what the third department said, they noted that 9.31 and 15.31 specifically are sealing provisions, and that therefore those provisions would really be meaningless if in fact 3313 required sealing. So
what's the point of adding in that they're not public why would the legislature include that? What's the purpose?
in 3313?
Correct.
Well, because clearly that relates to civil proceedings. These cases, the
But these are civil
33020,
proceedings?
well, they've been called quasi-civil because the defendant is still subject to a criminal statute, 33020. Even in Track 2 and Track 3 cases that was mentioned a moment ago, I believe, as you pointed out, under 33020 subdivision 7, that if the defendants are found Track 2 or 3, they're governed by the mental hygiene law. However, they are still governed by 33020. They do come up for review.
Does that mean they somehow their rights are diminished, given that 330.2017 says they have the protections of the mental hygiene law?
They're diminished to the extent...
Let's assume it's a quasi,
Yeah.
as you say, quasi-proceeding.
Yeah, I think they are limited at least to the extent that any other criminal defendant has their rights somewhat abridged because of the fact that they took a not responsible plea. Under Track 2 and...
But then the court decides that they really do have, let's stay with the Track 2, Track 3 for one moment, really do have the mental defect, mental disease, mental illness, whatever the specific language is. It seems in the mental hygiene law that the legislature's policy decision is to protect that very type of personal information about one's medical status and how, in these cases, it might be relevant to their legal status.
Except that, as Judge Fahey pointed out early on, these cases are somewhat different in that they begin with a criminal prosecution, which is public. There are usually hearings, which are public.
They're talking about hearings post that, once they're now in the mental hygiene, under the mental hygiene law rubric.
Yes,
They're
and
patients now.
certainly for a Track 3 such as this defendant, in most courts, those subsequent proceedings are public. Orange County Supreme Court meets every Wednesday. Those proceedings are, by and large, public proceedings, where a defendant, if he is put up for retention, for example, is subject to a hearing that's done in open court. Doctors come in from the hospital, possibly their own doctor, and they testify publicly about what the defendant's current condition is.
But it's sealed, yeah? The documents?
No, it's not.
The records are not sealed?
To my knowledge, they are not sealed, Judge, and as we're pointing out, there really is nothing in 33020 that requires sealing, and I don't think you would expect to find that because the whole point of 33020 was to enhance public safety. And if you look at what was going on around the time of the Insanity Defense Reform Act of 1980, you had the Adam Burwood case, you had the Albert Fentress case.
Well, that really was about President Reagan eventually, wasn't it?
Well,
The great changes took that.
Hinckley as well, the Hinckley shooting. But the point was for the enhancement of public safety. And so there really is no sealing provision in 33020. Now, what is troubling is that under MHLS's argument, if an SHTA or a staff member or a nurse or a doctor puts a note in the clinical record that it would refer to, say, what the defendant was charged with or what the court's original conclusion about his current condition was, that suddenly that requires sealing of court records. And that clearly can't be because it's the court that's responsible for their own records. It's the court that should do the sealing if there is to be any sealings. And under 33020, none is
What
required.
court record would not reveal the patient's identity or something about their medical condition?
That's part of the problem. Because these defendants are here from a criminal case, very often acts of violence, very often crimes that were notorious, that were publicly reported, and to think now that simply because...
And then they were found to have a mental defect or disease, so now they're
Correct.
patients. So the question is, what then does the law provide for them? It
This
may be
court-
correct. The court may decide you
Well,
don't
this
get
court
to
has
seal it.
decided, this court has decided that a 33020 insanity quitty has not the same rights as a civil defendant. The United States Supreme Court has decided
Well, with
the
respect to
same
the
thing.
procedure, I understand that, but here we're talking about the privacy interest. And it's clear the legislature thinks that they should be treated pursuant to the mental hygiene law, that those guarantees
Well, with
apply.
limitation, I think the wording out of 330-2017 is
Right, all
subject
I'm
to the
saying is there's
limitations
nothing
and
expressed
provisions.
in 330.20 that says they don't get sealed. So
No,
this
but there's
is a way
nothing
to harmonize
expressed.
it.
There's nothing-
But there is the cross-reference and the specific language that refers back to the mental hygiene law, and the mental hygiene law in that way is
Sure.
very clear.
But I think you also have to look at the distinction between a civil and a criminal patient. A civil patient typically hasn't committed a crime. Typically, they don't place their own mental condition in issue. Very often, it's the police, it's a family member, someone who's called the authorities and said this person needs help in a psychiatric facility.
I understand
So-
your argument, but yes, of course, this is an individual who's found guilty of a crime, but then there is a court, and the legislature has recognized that if that person is not culpable in the same way as someone else, given the nature of their mental disability, then we give them a different treatment. That point, they are now a patient. And
Well,
that-
and I
that's
think-
all I'm pointing out to you. I'm not disagreeing with you. on the
Counsel,
first
could we
part.
get on to a different issue now?
Sure.
Going back to something the Chief Judge said, if we were to disagree with the sealing, the additional sealing done by the appellate division, is there a way for us to reach that on this appeal? If we think that wasn't necessary, for example?
If you think that the
Redactions,
redactions
I'm
were
sorry,
not
yeah.
necessary, in other words, do we have standing? Our position would be yes, because really you have to decide what the limits of confidentiality are. And one way or another, it's going to affect whether that's through redaction or no redactions are needed. So I think, in
Well,
effect,
but
you're going
that-
to reach that anyway.
But it's either reviewable or it isn't in this particular
Well,
case.
it was certainly-
Ultimately, you may be right, but that doesn't answer the question of whether we can reach it here.
I think, first of all, it was adverse to the defendant, because they wanted full redaction and the court only gave partial redaction. So certainly, I think you can reach it under those terms. If I could just switch gears again, there is another issue here, and that is the presumption of openness in all court proceedings. And the fact that it's not just the defendant who has the right to that open proceeding, but the public has that right to the open proceeding as well. And I won't go through it here, but in our brief, we lay out some of what Dr. Frazier said in her application about defendant, having to do with his, I'm sorry, I see my time is
You
up.
may continue.
Having to do with how he relates to women. That goes to safety. It goes to public safety. And certainly, if we're reviewing his case, it should be in a public proceeding, the way it is through most of the state now. And the public should be able to gauge whether a defendant is being treated properly under 33020, whether they're being released precipitously.
If there is let's say, a case where there is a victim of a violent crime, and the records are sealed, according to what your opponent is asking, is there a separate provision of law that provides for notification to the victim of the proceedings that take place after the initial criminal action?
My understanding, I think we would be limited probably under 33020 subdivision, I think it's 22, that would provide for a special order of conditions, which would actually serve very much like an order of protection. So I suppose you could do that, but that would
There's
really
not a
kind of be after
standard-
the fact.
There's not a standard provision in the law that provides for notification to victims in this circumstance.
In this circumstance, I don't think so.
Thank you, Counsel.
Thank you very
Counsel?
much.
Thank you. Judge, if I could begin by answering your question, there is a specific provision, CPL 33020 sub 18 provides, this is with respect to track 1 patients. It provides that notwithstanding any of the provision of law and a person confined by reason of commitment order shall be either discharged or released unless the commissioner shall deliver written notice to the following people. 1 is the district attorney. B is the police department having jurisdiction in the area to which the defendant is discharged or released. And C is any other person the court may designate. And certainly that would include or could include a victim or the victim's family. There's a separate provision.
That's a notice of a result?
It's a notice of an application to either discharge or release. And these people are given an opportunity to be heard, not just notice of a result.
And if they come in and they're heard, is that sealed under your rule?
It would be sealed to the public,
Right.
but their access to the records wouldn't be.
So they could have access to the entire court record, the victims?
I would say that their notice wouldn't be sufficient unless they had access to, and they can get access.
Why wouldn't it just be limited to notice that there was an application without any of the records?
Well, that would hinder their opportunity to be heard if they wanted to object to the application.
Where does it say that that's an exception?
3313C would provide them access to perhaps the entire clinical file, if that were relevant. So they could make a separate application to the same court for full access to the clinical record, and then they could sufficiently be heard in any application for discharge or release. Also, there's this section below that, sub 19, provides that any victim or other appropriate people be entitled to notice of any escape.
But doesn't that sort in some way reinforce, which has been a back and forth for a while in this argument, that this still retains the elements, some elements of a criminal prosecution? There is still some interest here in terms of a victim, a crime, or disposition in a criminal case that now is continuing, especially in the sense that you're requiring notice and an opportunity for a victim of a crime to come into this type of hearing. Doesn't that somewhat emphasize the fact that this is very different from your ordinary civil commitment proceeding?
I would agree with that, Your Honor, for certain individuals, for those individuals, not for the public at large. The public at large does not have an opportunity to be heard in the context of a release or discharge application. The public at large, to the extent that they're not represented by the people or the local municipal law enforcement, they don't have a separate right to be heard or a separate right. To be clear, what the people are arguing for here is open records.
We're not talking about the right to be heard, we're talking about the right
to protection.
To the records.
And I,
To the records.
to the
I think if I understand Judge Garcia's question is, it's a more general question. We're really looking at not a purely civil proceeding here. We're looking at least a quasi-criminal proceeding because these things suggest that it's more than just a civil proceeding.
well, I think with respect to track 2 and track 3 patients, which I also wanted to clarify, James Q is a track 1 patient. He's not a track 3. And also, to the extent that there are proceedings involving track 2 and track 3 patients that are open to the public, that's a misapplication of law. Those proceedings should be sealed pursuant to CPL 33020 sub 7, which states that those proceedings are specifically governed by Articles 9 and Articles 15 of the Mental Hygiene Law, and there's no limitation in that section or anywhere else in the criminal procedure law that limits Section 931 and 1531 as far as their sealing provisions go.
Thank you, counsel.
Thank you.